Hey guys, welcome back to the channel Meet Praneeth. So today we have a very special person with us. We have Emily Sumner, who is the founding attorney at Sumner Immigration Law, and she's here to discuss with us some important discussion about EB-1 and in general the immigration and how things are moving in US immigration system. So Emily, thank you so much for taking the time, and the stage is all yours. If you don't mind, if you can introduce yourself. Thank you.
Absolutely. Thank you so much for having me. I'm happy to be here. So as you said, Praneeth, my name is Emily Sumner. I practice immigration law. I have my own practice, Sumner Immigration Law. We're based in Richmond, Virginia,
Mhm.
and we serve clients all over the United States and all over the world. We have a team. There's another attorney and then a team supporting us as well. And all of us are based around the United States. That's one of the good things about COVID is I realized we don't all have to be in the office. So we have people all over Texas, Massachusetts, New Jersey, here in Richmond, South Africa. It's nice.
Great. And I think Zoom has played an important role in that, right? Connecting
Absolutely.
people across.
Absolutely.
It's amazing. That's amazing.
Yeah.
So what motivated you to do immigration law or like get a degree in immigration law? Or were you interested in some other kind of practice but switched your way to immigration? So how was that? What motivated you to do that?
Yeah, absolutely. So I was a Spanish major in undergrad and university, and I wanted to practice speaking Spanish with native speakers. So I asked my Spanish professor, what can I do? How can I practice with native speakers? And this was in North Carolina. And he said, oh, there's this immigration attorney in town, and you should talk to her. And I was 18. I'd never heard of immigration law. I had thought about law school, was definitely interested in law school all through high school, even middle school. So I went to talk to this immigration attorney, and I was persistent.
Mhm.
One thing that immigrants in the United States know about, I know you have to be persistent. So I was persistent until she gave me an unpaid internship for course credit
Mhm.
and a small stipend. And I was an intern over a summer break and I loved it. And she loved me.
Mhm.
And I stayed on as a student paralegal the rest of my career.
Wow.
And at that time, it was some employment based and some family based. So I did have the opportunity to speak Spanish.
Mhm.
And I went to law school specifically to become an immigration attorney. I would not have gone to law school for any other reason, I don't think. I don't know how much you know about law school, but you don't you study to pass the bar. You take courses to pass the bar exam at the end of all of it. I
Yep.
took one like 2 credit course on immigration law and of course loved it.
Mhm.
But didn't really study immigration law. There's not really the opportunity. And it is good to have a broad base of knowledge in law,
Right.
of course.
Right.
But I got an internship in immigration law my 3rd year. And then I was an associate attorney with that same attorney for about 6 years after I graduated. And she practiced employment-based immigration law. So that's what I learned to do. And I really enjoyed it. Family-based as well, some family-based as well.
Mhm.
Interestingly, not a lot of our clients then or now speak Spanish.
Wow.
So I rarely use my Spanish skills, but I'm so grateful that my love of the Spanish language took me and of studying other cultures brought me into this career in immigration law. I'm very grateful for that. And I love what I do most days.
Great.
I'm sure that is how it is for everyone.
There are always bad days in each field, right? But
For sure.
I think immigration law must have given you the opportunity to meet so many people, like diverse
Yes.
people across the world, and that's so beautiful. Like talk to them and learn about their field, culture, whatnot. So I think that's amazing.
Absolutely. One of the things I love about immigration law, I love many things about it, but one of the things I love is helping people, helping them achieve their goals and their dreams.
Mhm. Yeah,
Learning about different cultures, learning about where they come from, just interacting with people from all over the world, and also learning about what people do professionally. I have learned
definitely.
about so many different professions
Right,
as an employment-based immigration attorney that
right,
I did not know existed. And it's really fascinating to learn, what different people do.
right. No, I think you're right because my knowledge of law was limited to watching web series like Suits or probably
Yeah,
Boston Legal.
yeah,
But when I came in interaction with like Tess and other attorneys, and you yourself on LinkedIn, I came to know much more about law and how difficult it is to practice it, right? Because a lot of people had shared stories about their bar exams, and it's very difficult to get through, right? So I know it's like we always think our field is tough, but when you look at the other fields, there are equal, I would say more tough. I would definitely say that. But
yeah, absolutely. And it's kind of one of those things where whatever the opposite of the grass is always greener on the other side is, I always think like I was talking to my parents about CPAs
Mhm.
earlier this morning about how that test is so hard.
Right.
I think it would be, I would not pass like the basic chemistry class to become a doctor.
Right, right.
So yeah, I appreciate that everybody has different skills and talents and is
Right.
interested in different things. That's what makes the world a beautiful place.
Yes, exactly. And I think that kind of leads me into this question. I think you kind of answered it, that you focus mostly on the immigration from the employment-based and the family-based cases, right? But
Yes.
is there any specialty that you really like working on certain cases when compared to others, or any kind of preference in terms of immigration?
Sure, absolutely. Within our practice, it is, I would say, like 90% employment based and about 10 to 15, maybe 20%, depending on the caseload, family based.
Okay.
Within employment based, we focus a lot on professionals. So again, going to your point about, it's hard, there's a broad spectrum, even within a particular field. We don't do a lot with H-2As, seasonal workers, Js. What we do is a lot of work with professionals. So companies, we represent companies and individuals who are here working on different, the alphabet soup, the different visa classifications. H-1B is the primary one, although, as you know, it's increasingly hard to get that, at least as a new visa.
Right.
But H-1Bs, TNs, H-1B1s, E3s, E2s, all the different letters, Rs, religious workers. And then we help people through the green card process. Mostly the employment-based, though, like I said, family-based is also an option as well, as long as it's a valid family relationship. Right. But within the employment-based, we do a lot of perms, I-140s, religious workers. We also do EB-1s and IWs.
Wow.
I used to do a lot more of those earlier in my career, especially when I was an associate attorney. We were on the list of appointed attorneys for the state. The Commonwealth of Virginia has a list of attorneys that universities can use. And so we were one of the go-to attorneys for all the EB-1As, for the EB-1Bs, but, we would assess the resume and see if they were, which one was a better fit. Sometimes it was actually an NIW and they would self-sponsor. Wow. So that's the bulk of what we do now, is mostly H's and perms, I-140s, and then, like I said, the other alphabet. But we have extensive experience with the EB-1s and NIWs. Right.
And I think that's kind of our center point of discussion in this talk, because if you look at people coming from India, specifically working on H-1Bs, or let's say O-1, the major hurdle in immigration is the long wait time, right? It's I think a lot of people talk about it as a 75-year wait, or some say it's 150 years of wait. So, and that's if that's the case, then people need another way of getting to a permanent residency. So the time and money that they invested in the country, so they can permanently live here and work here and have some freedom of doing things. And I think EB-1 becomes a very important class in that scenario, right? So according to, because you've worked on so many cases and represented so many clients, companies, how feasible is EB-1, right? What exactly is required to get to EB-1 from your perspective?
So classic lawyer answer, and you might have seen me say this on LinkedIn, it depends.
Yeah.
As you know, the EB-1 classification is designed for individuals who are in the top percentage of their field. Unfortunately, it is not designed for everyone. I'm not saying that it's not possible to do it. I have seen clients over the years have EB-1s approved that I didn't think would be approved, or that I thought would be really challenging. So absolutely, there are creative ways to think about it, but it's designed for individuals who are at the very top of their field. When I say field, it does not have to be, I think a lot of times we think about EB-1s for professors and researchers, right? People doing medical research at Johns Hopkins, that's the kind of what I think of, at least for the EB-1s. And that's kind of can be a more traditional case type. But I've also, the regulation says that it's available for people in a broad array of fields. In science, yes, but also education, business, athletics, and arts as well. So it's not just limited to individuals who are, at the bench doing research every day.
Right. And I think you're right. And that kind of leads to my next point is, generally speaking, when I was filing my EB-1 case, or at least when I got to know about EB-1, and that's even an option for me, because I had a master's degree, I never had a PhD. And I think this kind of I would say this thing goes around that, well, if you have a PhD, you have a better chance to get into EB-1, right? Or I think the other statement would be PhD is a requirement for EB-1, right? But when I got to know about it, when I read through USCIS website or through other attorneys, no one said that, well, it's not a requirement. USA has not mentioned as a requirement. It's just you should have an advanced degree, right? So, like, do you also see this thing that a lot of people with PhD come to you for EB-1, or is it like a diverse group? Like a lot of people come and they have different degrees and stuff.
It's a diverse group. Most of the time, the individuals who come, who are interested in EB-1, yes, absolutely have a PhD.
Right.
But it can go both ways, right? Just because you have a PhD does not mean that you're eligible for the EB-1. There's like you said, there's the list of the regulatory criteria that are outlined, and PhD isn't on that list. Right. At the same time, like just because you don't have a PhD doesn't mean that you're not eligible for, you have to look at the regulatory criteria. I think another thing that maybe is confusing for individuals, a lot of the clients that I talk to are confused between the national interest waiver, which is in the EB-2 category, and the EB-1. And even the national interest waiver there are a couple different options within the NIW classification. One, yes, you absolutely have to have an advanced degree. The other one, for exceptional ability, you don't necessarily have to have an advanced degree. So I think there's a lot of confusion because people think of kind of this bucket of case types where you don't have to have an employer sponsor you, which is true for the national interest waiver and for the EB-1A. Right. But I think there's kind of some confusion in people's heads, and information out there can be very confusing depending on what you're reading on Google or wherever. But I think that also contributes to the confusion about this thought that you absolutely have to have a PhD in order to qualify for the EB-1.
Right. And I think leading to that, basically, what I've also seen is when I talk to people, right? So what I did is after I got my EB-1, I started this YouTube channel to basically tell people that or spread more awareness about EB-1, right? And I think these days we are seeing that a lot of attorneys are also speaking about it. A lot of people are also coming in picture and then trying to spread the awareness. But still, when I talk to people and they say, okay, well, I do not have research papers, right? I do not have any kind of research background because I'm let's say, tech lead, or I'm a product manager, or I am a chemistry department, or I do chemical engineering. So how is EB-1 feasible for me, right? This is one of the questions that a lot of people will maybe ask you as well. So how do you respond to that? Like, for example, do you think that research papers is a bar at getting at EB-1, or is it just a myth? And there are other criteria that can lead you to EB-1.
Oh, there are absolutely other criteria. There's the list of 10, criteria and the regulations, and you have to have at least 3 of those. Mm-hmm. I will say that generally speaking, just because of the nature of the, what's outlined in the regulations, mm-hmm. it is those criteria do lend themselves more naturally to individuals who are more research-based and publish papers and attend professional or, present at professional conferences and that type of thing. Mm-hmm. So there's kind of this bias, if you will, in the regulations towards research-based professionals, but it's not limited to that at all.
Right. And you can basically not answer this question, but out of curiosity, I'm asking this is, do you think that bias would also be in the minds of USCIS officers?
I think that's entirely possible. Absolutely. Mm-hmm. I spend so much of my time, mm-hmm. A, educating clients, which I love doing, and B, educating USCIS officers or Department of State or Department of Labor, whichever agency we're working with. Mm-hmm. But with USCIS especially, there are so many times that I will either proactively have to let the officer know, outline in as clear language as possible what the requirements are, what the regulations are, and what that really means. Right. Or do that in a request for evidence, if that comes up. But absolutely, I think it's possible that there's bias. Of course, depends on the person, for sure. I always tell clients that immigration officers, whether we're talking about Department of State at the consulate or Department of Labor or USCIS, whatever it is, they're people. Yep. So every person is going to have their own knowledge base and their own biases and things like that. But yeah, I think that's absolutely possible. And especially if you're applying for the EB-1 in a profession that isn't as part of the sciences in the scientific field, then I think it's really important to set the stage and really educate the officer on exactly what your niche is and how you meet the criteria that you're going for.
Right. Yeah, I think you're right. So very straightforward to the point description of what exactly you're going after. And I think this is something that I have been seeing in the on LinkedIn or other platforms that now people are talking about the tech field in general, like, or let's say finance or other fields which are eligible for EB-1, so that people can get educated. Because when I was applying, I could see this clear bias that among the attorneys as well, that, well, if you have papers, if you have citations, then you have a better chance at scoring a EB-1 case.
Right.
So that's why I had this question.
For sure. For sure. I hesitate to use the word easy and anything immigration related, but it is easier in general, depends on the case, and the specific facts. But I do think that there's a bias that, it's easier to have an EB-1A approved for a scientific type who has lots of papers and publications and all the things. You definitely have to apply more creativity and outside of the box thinking for an individual who is, like you said, in tech or business or arts even.
Right.
For sure.
That makes sense. And comparing to O1, I think this is kind of a follow-up discussion point. So, like, for example, H1B, as you know, it's a lottery system, right? And with the multiple registrations that happened for the 2024, a lot of eligible people didn't get a chance, right? Because if there are a lot of people were filing multiple fraud registrations. So O1 becomes another kind of class of visa that people can go for, right? So how would you compare O1 to EB-1? A lot of people think that's very stringent, it's very difficult to get. But do you think that if you have specific points, you can go for O1 before even going to EB-1?
Yes, absolutely. So in general, it's easier. Again, I hate to use that word in the immigration context, right. But in general, I will say that the standard is lower. So the regulatory requirements are somewhat different. They're very similar, but they're somewhat different. Okay. And in general, because the O1 is a temporary visa, their USCIS is going to have again, depends on the officer, depends on what mood they're in, all sorts of factors. But in general, it's easier, I would say, to have the O1 approved instead of going straight for the EB-1. It depends on a number of other factors, of course, as well, depending on, the immigration situation, the individual's situation. Right. But absolutely, it's easier. Now, there are situations where a person will say, I have the O1 approved and I got it approved, without RFE, it's amazing. And so let me go for the EB-1. And I really recommend that before you do that, you speak to an immigration lawyer who has lots of experience with EB-1, because it absolutely may be a strong case and you may be ready to file right now, or it may be that there are certain things that you need to work on in order to strengthen your case. So just because you have an O1 that doesn't mean it immediately translates to an EB-1. Makes sense.
And I think in regards to that, I have this paper where I have a discussion point for you, where I have this pseudo profile that I created, and I just wanted to take your opinion on what are the things that you think are there which could be source for EB-1 criteria or evidence, and what are the things that someone like this profile should do, right? And I think I tried to pseudo this to a case which would be, you found a lot of similarity with other people. So and sorry for holding this here because I just want to get it out. So let's say the profession is a product manager and the education is master's in computer science. And they have around 10 to 12 years of experience working in the field. Like, let's say they were a software engineer, transitioned to a product management field, and they have news articles for the product that they have built. And but the articles are more focused on the product rather than the person who was managing the product. And they have probably a high salary criteria in their bag. And critical role is something that they are aiming for, but do not have it right now. And they have reviewed the code of others on GitHub or other platforms, right? But they have not reviewed research papers or peer-reviewed research in general. So how does this case look to you in terms of EB?
It looks hard. To be honest, it's one of those that I said a minute ago, that is, you have to apply creativity and outside the box. And it may be that, so you all know this, but nothing that I'm saying is legal advice. All this is just for informational purposes only. But this is definitely a case, if this came across my desk, if somebody scheduled a consultation, for example, with this background, it's something that we would have to really dig into their background to see what they may be qualified for, and then what they may need to work on in order to apply down the road. Right. So the number one thing that I would say with any EB-1 case is that if you there's a criteria for having made a significant contribution to the field. So that doesn't mean to your company or your department, but it means to the field. So I believe that if you don't meet that criteria, then what are we doing in EB-1 land? I really think that you have to make sure that you nail that criteria, and then some of the other criteria build off of that as well. But I think that's absolutely critical. So that's the number one thing that I would focus on is what is your original contribution of major significance to the field. And I think it's important to clearly define your niche. In this particular situation, you're a product manager, you maybe have developed a software product. So you don't want to say that your field is software development, right? Because that's huge. It's absolutely a critical part of the EB-1 strategy is clearly defining your niche and exactly what your field is. And that's one of the good things about the EB-1 is you can do that. You can define, you can't say software development in pure Iowa, whatever city, it can't be ridiculous like that. But you can be creative and say, this is my field, this is my niche. Right. So I think that's the number one thing that I would look at and talk to this prospective client about. The media attention and the kind of profile that you sent to me, it says a news article for the product that they helped develop along with the team. That's interesting. That's something that I would dig into. That alone is not going to meet the regulatory criterion because it's not necessarily about the person. I would look to see, is the person's name mentioned? Is the prospective client's name actually mentioned in the article? Does it talk about what their specific role was? But if it's just that, Microsoft rolled out this product and it's amazing, and they don't it's not specifically about the prospective client, that's not going to meet that particular criteria. So I think that's really important. And it's hard to do, right? You can't control what the person writes about you necessarily. I mean, I know I've heard on and off about people trying to work with PR companies, public relations companies to try to get press about them. I think that could work possibly, but you have to be careful about it. But that's something that I would want to dig into. Another, I know you mentioned critical role and you said no, that the person doesn't have a critical or leading role. That's something that I would want to have a more detailed conversation with them about. Is that really true? Because if they are EB-1 criteria, or if they're EB-1 material, then they probably do have a leading or a critical role. Again, that's not, there's all kinds of case law about that you would want to look into, or the attorney rather would look into. But I think it's possible. I've used that criterion before for individuals that on first blush, they came to me and they're like, no, I'm not that important in my company. Well, you did something to merit the EB-1. We think collectively that you are eligible for EB-1. So you've made a significant contribution. And that can be documented in different ways. Typically, the way that I've done it in the past is a really detailed letter from someone really high up in the particular organization, whether that's a company or a university, whether it's at a university, the dean or the department chair, whatever it is. But it's possible that you could dig some more and possibly use that as one of the criterion that you're looking at.
Right.
High salary. On the profile that you sent me, it says median salary as per Glassdoor. And I think that's a great point. You do have to compare yourself, document for everything, for every criterion that you're trying to meet. You have to clearly document. It's not enough to just say, yes, I have made an original contribution, and just have your lawyer write a letter that says that as well. That's not going to work. But to the salary point, that's something that's pretty easy to document. And there are multiple sources that you can look at, whether it's Glassdoor or the Department of Labor has data on salary information as well that can be helpful, especially because it's government provided. I think that can be helpful. But it may be that you don't meet that right now. That may be another, part of the conversation that we have, that you don't meet that right now, but are you up for a promotion? Is that going to happen? Is that likely to happen in the next year, 2, 3 years, whatever it is? Or are you able to change positions? And, you have to be careful about that because that may affect other criterion that you're working on. But are you able to change companies and perhaps bump up the salary and be able to meet that criterion?
Got it.
There was something else I was going to mention. Oh, membership in associations is one thing to be careful about. There is, it is not enough to just be, and you've probably talked about this extensively already. It's not enough to just have joined an association, right? I'm a member of the American Immigration Lawyers Association. I think I'm a great lawyer. I hope so. But that would not meet the EB-1 criteria, right? Because I pay them a few $100s a year. I show them that I'm a licensed attorney, and that's it. It's not, I didn't join because I'm a great lawyer.
Right.
Or that's not why they let me join. So it has to be an association that requires outstanding achievement in order to join. And you have to again, documentation is so important. You have to clearly document what that criteria is. It's helpful if you have information about the pool of applicants, like how many other people, what are their backgrounds, what caliber person are you competing with to get into this organization, that type of thing. Depending on the person's background, that might be something to look into.
Right. And on the like a quick follow-up on the news article about the product, right? So a lot of people ask me this. So let's say, because Microsoft, Google, Apple, they are huge companies, right? And generally the PR of these companies will roll out the product news or any kind of media event, right? So let's say I worked on a product A, and that is released in the newsletter, or let's say it was covered by the PR. Then if I get a letter from my manager or a director or someone higher in the company hierarchy who can document that, well, yes, I was one of the lead, let's say, individual contributors or critical aspect of this product. So would that, in combination with the PR, be evidence?
I'm sure that there are situations where that has worked. It's not something that I would recommend. And there are sometimes in cases like this, you have to document at least 3 of the 10. So the short answer to that question is no, it's not something that I would recommend, because that's not what the regulation says. It needs to be media about you specifically. Right. However, you have to meet at least 3 of the 10 criteria. You have to be careful about, some people say, I've talked to clients over the years and they say, oh, I meet these 7 criteria, let's document all 7. You have to be strategic. My take on it, my approach is you have to be strategic about it. You don't want to submit all 7 if some of it is weaker, and you effectively water down the rest of it, if that makes sense. But there have also been times where I have made an argument, let's say that there are 5 criteria that I think are fairly strong, and that the person meets. And I've made the argument, especially in RFE responses, request for evidence responses, that, hey, this person meets these 5 criteria. Here's the clear documentation. But even if you don't agree with A and B, they still meet C, D, and E.
Right.
So you can use, and the other thing is you can use one piece of evidence to meet multiple criterion. So for example, I've done that before with citations. I know that's not as big of a thing for an individual with your profile, but if a person has hundreds of citations, I've used that to argue to support multiple criterion before.
Right. And I think that could be also evidence of work written about you or your research, right? So because let's say I have a research paper and that's being cited, so that could kind of be used for this criteria, right? Where your evidence of have been articles written about you or your work, right? Something on those lines, basically.
Right.
And that paper would also be an evidence for scholarly articles or professional articles. Right?
Possibly, yes. Yeah.
That's amazing. And the other thing that I wanted to ask is, and not about this profile, but in general. So I think evidence of original contributions of major significance, right? That is one of the criteria that is important, first of all, to show that you have contributions outside of your work or within your work, which is of significance. Now, in this one, let's say I have developed some products, right? Or let's say software products or technical products or mathematical models or something like that, which are now being used by other companies or let's say clients. And they are basically, those clients are benefiting from that product in terms of, let's say, revenue, technology, or any stream or space. Would that be considered as a contribution of significance?
Yes, absolutely. I think so. Depending on how you present it, how you document it, absolutely, it could be valuable information. It would be important to get independent evidence, maybe letters of recommendation from those companies that outlines in detail how they are able to use that, whatever it is, the product or the mathematical models or whatever it is in their work and how it benefits the company. But I think that's tremendously important, especially for something that's not widely applicable, like cancer research, for example, to show that it's not just whatever it is that you've come up with is not just benefiting your company or your department, but that that's one of the requirements, right? Is that of that it has made an impact on your field as a whole. So I think that, yeah, could definitely be helpful.
That's very good to know. I think that would really help a lot of people who are in this domain where they have developed a lot of things and being used, but don't know how to use it, utilize it, and maybe they can come and talk to you to get more insights on it.
For sure.
And I think that kind of leads to another question where there's a criteria which is evidence of having awards, right? And generally speaking, those awards should be of high status, like, for example, international or national awards. But let's say someone is in research, or let's say in tech industry, where they got awards from the niche that they're working. Like, for example, their conferences have given them awards, or let's say in research, they have got an NIH grant to work on a research or based on their previous research. So would that qualify as substantial evidence, or would it be a supporting evidence?
It depends on the particular, I know, my favorite answer, right? Yes. But it depends on the overall, it depends on exactly what award has been granted, and it depends on the overall profile of the person, and it depends on how you're presenting it. What kind of documentation you have to support it, and what kind of documentation you have to show the importance of that award. What you can't use, and I think your viewers probably know this, but things like travel awards that you receive, or awards for the best poster presentation at your at the presentation at your university, your local university, that type of thing is not going to be helpful, and I think would weaken the evidence, kind of water it down. But if you're able to show that the award is a national award or international award, and if you're able to show the importance of it, and again, that ties in closely to defining your field. And that's a key strategy for the whole EB-1 case. But yeah, it's possible for sure.
Right. Yeah. So for example, a federal grant could be an important evidence to show. Yeah. You will have to see how you will basically showcase it.
Right.
On that regards, so this is something that I'm asking out of my curiosity, right? So for example, there are, let's say, 2 classes or 3 classes of evidence. When you have is primary evidence, which is directly helping you prove a criteria. Then you might have supporting evidence, which showcase that, well, it's not supporting a criteria, but it helps you show the importance of your work, or let's say your significance in the field. And then it could be tertiary criteria, which is tertiary evidence, which is just something that you did, but it's not important in terms of the criteria sense or landscape. So how do you rank them? Like, in terms of ranking, only primary evidence has weight, or you think even supplementary or like secondary or tertiary evidence also creates weight or has weight when you go for EB-1?
It's a fine balance, because you want to make sure that you clearly explain what you do in layman's terms, and clearly define in layman's terms the niche, your particular field, your niche within that field, that type of thing. So that's generally going to take a good amount of explanation and supporting documents. You also want to make sure that you clearly document how you meet each criterion that you're claiming to meet. It's, like I said, it's not enough to just show, or not enough to just make a statement that, oh, I have an original contribution. You have to document it. However, the flip side of that is you don't want to overpaper the file. Like I said, the people who on the other end who are reviewing this are not in your field. Probably. Right. We don't know what their education level is, not to belittle anybody who doesn't have a higher, degree at all, but we just don't know what their base of understanding or knowledge is going to be. So we have to speak to kind of a broad audience. But at the same time, they're a person, and they have like buckets and buckets and buckets of files to get through, and they are pressured, just like, all of us have hopefully productivity metrics in, employment. They do too. Yeah. So you don't want to make it a situation where you have where you have like a huge box full of documents that they have to go through. It's going to make their job harder. You want to make it as clean and concise as you possibly can without under documenting. So it's definitely a fine balance. But in terms of the third category of evidence that I think you mentioned, I would, depending on what it is, I would likely leave that out, because you don't want to, if it's not necessary for the approval or the adjudication of the case,
not required.
I don't think it's worth including.
Right. I think that will help a lot of people, because some people have this mindset that the lengthier your application is, the better you have a chance, which I tell people that, well, it's not true, because it should be more precise, to the point, and very clear. Because if you have tons of things which are not resonating with what you want to show, then that kind of goes in the negative direction, right?
Absolutely.
That is a great point. And I think that kind of leads me into my two or three final questions. I know I'm asking a lot of questions to you and a lot of discussion points, but this is again a myth that revolves around, and a lot of people ask me this question, or may have asked you as well, that what is the number of citations, what is the number of papers I should have to qualify myself as an EB-1 applicant, right? And I always tell them that, well, from my point of view, that it's all about quality and the impact, right? Even if you have one paper or two paper, but they are very quality work and they are very important in terms of what you're doing, then that could qualify as evidence. But this is a myth that, well, I need 50 papers, 700 citations and all that. So what do you have to say about it? Like, how would you balance it out?
Yeah, my classic answer, it depends. Not everybody who qualifies for EB-1, as we've said earlier, is going to have any papers or any citations or any presentations at national and international conferences or whatever it is that you're talking about. Every person's qualifications are going to be different, just depending on what I call their story, which is basically what you're telling. You're telling the story of not the whole story, but you're telling the story of your career and how you've really made a significant impact that is at the very top of your profession. So I think it depends, but yeah, it just depends. But there's no specific, and I think I agree 100% with you about quality matters over quantity. That goes to the Kazarian analysis, which you've probably talked about before, the two-step analysis that USCIS will look at. Did you meet at least 3 criteria? And if you did, that's great, but that's not enough. They'll look at to see what the quality of that criteria is. So it absolutely depends on the quality. It depends on your field, if that's even relevant. If you've published papers and it's not something that anybody else in your field does and nobody cares, then it's not going to help you. So it definitely depends.
Makes sense. Yeah, that's I think that resonates very well with what I think about and tell people. And I think my two final questions. One is, I think, very interesting, and you might have also come across this. Is a lot of people have this mindset, or have come across this as a myth, that filing in premium processing, your EB-1, can lead to an RFE, right? And I always tell them that I don't think USCIS is there to send RFEs. Their job is to adjudicate the case, whether it's premium or regular processing, right? But do you think there is some reason behind it that people have this myth that premium processing can lead to RFEs or something like on those lines?
It's possible. And I've tried to track that trend over the 18 years of my career and through talking to other immigration attorneys as well, because it's definitely a myth. It's something that we immigration attorneys talk to each other about as well, a lot. And there's a lot of different theories out there on it. And again, as I've said before, it really depends on the officer. Every officer is their person and they have different workloads and different work styles and, all the things. But I think it is possible. I'm not saying don't apply in premium processing because you're definitely getting an RFE. That's absolutely not what I'm saying. It depends on a number of factors, including the quality of the filing and other factors, including the officer that you get and what the workload is. But I will say this, I have talked to individuals who currently work at USCIS, current immigration officers and people who have worked there in the past. And they have metrics that they have to meet. There is, I don't know if the word is pressure, but they are under pressure to process a certain number of cases a day, but they don't want to approve a case that should not have been approved.
That makes sense.
Just like they don't want to deny a case that shouldn't have been denied, they don't want to approve a case that shouldn't have been approved. So in some instances, I think, and I'm not speaking from anything that anybody, at USCIS has told me, it's just based on other information, other conversations I've had with them. I think in some instances, it is maybe easier to press the RFE button. It's not like an RFE is automatically generated, although it seems like that sometimes the way that they're written. We do see a lot of copy and paste in RFEs, absolutely. But my point is that I think sometimes, absolutely, it's safer for them, so to speak, to issue a request for evidence than to approve a case that they didn't have time to fully review. The clock is ticking, they're on day 14 or 15. And so they just send a request for evidence. I think that's entirely possible. And I'm not saying every officer does that, for sure. or that that's the case every time. But I will say this, I get very nervous. I'm sure everybody does when it's day 14 or 15 and I don't have an approval yet. I'm like, for any case, even whether we're talking about EB-1 or anything,
The other
I'm
case.
like, oh my goodness, I think an RFE is coming. And that's not always the case. So if anybody out there is on day 14 or 15 of premium processing and you don't have a decision yet, hope springs eternal. I've gotten approvals on day 14 and 15 before multiple times.
Right.
But I think it's possible. Over the years, I've had other clients say, oh, I want to file in regular and then I want to upgrade to premium. And I don't quite know what the benefit would be there. But yeah, there are all kinds of very interesting theories out there about premium and RFEs.
Yes, and I got my approval on the 13th day, and you'll not believe, like, I was in India. My case was filed on November 18th, and I think I was at my friend's wedding, and I was very nervous. Like, well, the clock is ticking, and 4 days went. Like, a lot of people I talked to, they was like, "Oh, I got my 4th day." Some said my 7th day. Okay, 1 week is done. It's 2nd week. Still, I've not heard anything, and I was like, oh man, it's very, very frustrating.
I know.
Luckily, things went really well.
I'm so glad.
But I think you're right. It's nervousness and pressure is always there. I think on both the sides of the play.
For sure.
Right.
For sure. And with the RFEs, I'm sure you have talked to people who have seen this before, but like I said, they can be very much cut and paste. So it's possible that you receive an RFE that you feel like you've already submitted everything that they've asked for and more. Absolutely. Right. I've been there. Right. Or they're asking for things like, I have received RFEs that have another person's name in it, or they mention the wrong case type, like something that's just egregious. And you're like, it makes it really hard to respond because you're not sure if they've even read the case.
So in that case, you would just tell them that, well, this is not the right case, and they'll just review it again, or you have to go through the whole process of answering those questions. And
I err on the side of caution and answer the questions. I point it out. I say, well, that's not the beneficiary's name. Here's their name. And they say, the other thing is they say on the RFE not to send in information that you've already submitted. And sometimes a lot of times you're like, okay, then why are you sending me this? Because I literally have submitted everything you're asking for. So I mean, different attorneys have different approaches and I do it different ways, different times, but a lot of times I will resubmit because I'm like, you didn't look at this the first time. So how do I know that you're going to go back and look at it the second time?
True. Yeah. And I think
so fun.
Perfect. No, that is very helpful. And I think that leads to my final question before I'll ask for your words of wisdom through your 18 years of tremendous journey. So my question is that, let's say I'm filing an EB-1A, right? I'm self-petitioning my case. And let's say it gets denied or it's not accepted. And then my employer says, okay, well, I will file your case as EB-1B, right? So in case when I'm filing my EB-1B, when my EB-1A is already rejected or denied, would that affect any way my EB-1B case?
No, it should not affect your EB-1B case. I would definitely look to see why the EB-1A was denied. One thing about denials, nobody likes to get them, of course, but it's insightful, it's helpful to see how USCIS is thinking and what they will accept and not accept. You have to take it with a grain of salt because you're getting this denial from one officer, they're not stating like the global policy for USCIS necessarily, but it can be helpful. So I would definitely look and see why it was denied. The criteria for EB-1B are somewhat different. It's a similar idea, but it is somewhat different. So I would look and see why it was denied. But a denial for one type of case, unless it's something that is fraud related, of course, that's totally different. But a denial for one case, putting aside fraud issues, should not affect the adjudication of another case. And I've seen that time and time again. Where a person applies in one classification and it's not approved and another classification it is approved, or even refiling. I'm sure you've talked to people who have had denials and then refiled and the second one is approved, sometimes without RFE, which is interesting and great. But absolutely it shouldn't affect it. But I would look at why it was denied and see if you can shore up those reasons. The other thing that I'll say is there are possibly different adjudication standards for EB-1B versus EB-1A. Okay. I think for a variety of reasons, but I love this story. I had a client whose employer was not willing to, he was a professor, wasn't willing to file and, sponsor him for permanent residence. So we had to do EB-1A. His case was not very strong. I told him, like, I even had him sign a waiver saying, like, I don't think this is going to be approved, but he really, he had family here, reasons that he wanted to do it. So I was like, all right, we'll do it. We got the request for evidence as expected. I did my best. I, pulled together everything we possibly could. And I told him again, I really think, unfortunately, this is going to be denied.
Yeah.
And he's like, well, I have to do this. It's my only option. So I send in the documentation, Texas Service Center.
Okay.
The officer calls me. I still remember her name was Officer White. She calls me on the telephone. And this was years ago, it's probably 15 years ago now, but she calls me on the telephone and she says she has this Texan accent that I won't try to recreate, but she was so sweet. Right. She says, Miss Sumner, this is Officer White at the Texas Service Center, and I have your client's RFE, and I can't approve this case. And I was like, I know. Why did you call me? I didn't say that, but I was just like, yeah, I know. It's really not, I understand. And she said, but I can approve it under EB-1B. I just need the signed I-140. And I was like, oh my goodness. It was amazing. I didn't even have to send in, different letters. And this is an anomaly. Do not expect this. That's very unexpected. But my point is that there are different adjudication standards. There are different regulatory criteria and there are different adjudication standards. So if you don't qualify under one classification, take a deep breath and reassess. There are other options out there and you may qualify for something else instead.
That's an amazing story, like getting out directly from. Does it happen regularly or?
No, I have never heard of that happening. Like I have so many immigration lawyer friends and I've never heard of that happening. It's the only time in 18 years it's happened to me, but it was really amazing when it did happen. And I so appreciated her.
No, I think so. Like it feels so good, right? Okay, well, something is happening. At least, what's the right path again?
For sure.
And I know I have taken a lot of your time, but mainly any words of wisdom for people who will be watching. I think people from different domains are watching probably because it could be H-1B holders, it could be people who are going to file H-1B or O-1 or in different, let's say even STEM OPT or EB-1. So what is your words of wisdom in terms of US immigration system? I know it's not points-based. Still, there are some things that needs to be fixed, but it's something that we have to work with, right? So what is your advice for it?
My number one piece of advice is to take a deep breath.
Right.
If you look at it, you said when we first started speaking, looking at the priority dates, especially if you were born in India, it seems like it's going to, depending on the calculations you do, that it's going to take 150 years for your priority date to become current. Yep. But there are multiple options. One thing that I tell clients all the time is to plan ahead. I love it when I had an inquiry this week from someone who said, I am in X country, wherever it is, and they're coming to study on F1, but they know they want to stay here long term. Their immigrant intent issues. But I love that he is thinking long term about and trying to come up with a plan ahead of time. I absolutely love that. At the same time, so yes, have a consultation with an immigration attorney if you know that you even might want to stay here. Think about your different options, learn about your different options, watch shows like yours to learn your different options. But at the same time, realize that there are multiple roads, multiple paths that lead to the same goal. So if your goal is a green card and you think, okay, I am going to get there through EB-1, that's great. And that may or may not work out. Hopefully it does. But if it doesn't, there are other paths. So for example, I have a client that I've worked with for years. He came on H-1B. We did the traditional perm process and the I-140 petition. His priority date is, years and years and years away. He was born in India. Right. And later, about, I would say 7 years after we started the green card process for him, then he applied for EB-1A. If we had done that 7 years earlier, I really feel like it would have been denied. But he applied for EB-1A and it was approved. And now he's much, much closer to the point. In fact, he has submitted the I-45. So he's much, much closer to his goal of getting a green card. That wasn't perhaps how he thought he would get there for various reasons, but there are multiple ways to get to where you want to go. And multiple paths and multiple options and opportunities. So I know it can be discouraging at first, looking at the US immigration system and thinking, oh my goodness, the H-1B cap system is absolutely ridiculous. The priority dates are 1,000 years away. This is going to benefit my 5th grade grandchild. Not that it works that way, but it looks very, very discouraging. Right. But know that there are compassionate, empathetic people like you and like me and other immigration attorneys out there who are here to help you. We want to educate you. We want to support you along the way and help you find the most appropriate path to reach your goal.
I think that's an excellent piece of advice. I think I like the starting statement that take a deep breath. I think that's very important. A lot of people have to be calm, patient, and think about, reevaluate their situation. I think I would say it's an excellent piece of advice. And I will definitely put your LinkedIn link, and I think you have your newsletter. I'll put that link as well so that people can start to come to you, talk to you, get your insight on their case.
Great.
And thank you so much for taking the time. This is really, I'm pretty sure it will be very encouraging for a lot of people, and will also
Absolutely.
ask questions.
Yeah, thank you for having me, and thank you for doing this show. I know it's helpful for so many people, and I appreciate people like you helping us to put that information out there.
Thank you. Thank you.